I wonder if you could just talk a little bit about, your role, the role of a public defender in hearings and in the substance of outcomes, under the previous system, before we had the Pretrial Fairness Act in effect, and sort of what that was like for you as a public defender.
Sure. Well, up until a year ago, of course, we had the cash bond system, which meant that when we went to bond hearings, we were trying to get the lowest cash bond amount for our clients that we could. As of 2018 or so, our public defender's office was always present at these bond hearings. We'd be presenting evidence to the judge about the defendant's background somewhat, but really our focus was on getting the bond amount as low as we possibly could. So we were dealing with bonds being set in cases that ranged from small amounts of cocaine residue all the way up to murder cases, and just trying to get those bonds to some reasonable amount that a defendant could post. And then, of course, with that amount, the defendants would have to post 10% of that bond. And at the end of the day, that meant it was very possible to have defendants held in our jail for nominal amounts because they simply couldn't afford to post the bail. We'd even have unusual situations where we would have somebody on bond for a murder case because they could post, say, the $100,000 required, but someone who had a residue case or a lower level drug offense might be stuck in the jail until their bond came down low enough for them to be released. So we had some issues there, but really those bond hearings were focused on money. And that meant there were wide discretion between the judges in setting the amounts. It depended on what judge was in court that day, if the judge remembered that defendant from a prior case, things like that would really play a big role. And so we were just arguing about money is really what our bond hearings used to look like.
Liz Pollock, I wonder if you could then sort of describe how that's changed under the new system, both how the hearings have changed, and I think really any kind of examples that you might have for how cases are treated differently, how outcomes are different, candidly, how your clients feel about this system now that it's changed.
Sure. Well, I mean, I think the biggest thing is that we have so much more information now as we're preparing for these hearings. When we would go into court for bond hearings, first of all, the hearings would take probably no more than 5 or 10 minutes because we had a really limited universe of information that we were looking at. And all we could really tell the court was what our client had told us during intake that morning about what their connections to the community are and what their financial resources were. One of the biggest changes under the PFA is that now we are entitled to receive all of the discovery that the state has relied upon in deciding to try to detain the person. And so we have a wealth of information about the case much, much earlier, which enables us to have intelligent conversations with our clients about, what the burden of proof is going to look like, what issues we could raise at a detention hearing. And the hearings themselves are taking between 20 and 30 minutes. I actually just got finished with one that took almost an hour. And that's because the judges are able to see this much broader universe of information and make a better informed decision. In terms of how it's been affecting our clients with bond amounts around $10,000 to $15,000, they just could not come up with the 10% to post that. And so you have somebody who has a really limited criminal history, somebody who has no financial resources, and they're stuck in the jail. They lose jobs, children, they lose pets, they lose such enormous chunks of their lives simply because they can't afford to post. And now I think what we're seeing is that we have the people who are being detained under the dangerousness standard are the people who are charged with the really serious offenses, people who have lengthy criminal records, people who, for all intents and purposes, would have those massive bond amounts, but now they're detained under the PFA standard. And most of our clients who, would be otherwise stuck in jail pending trial are able to continue with their lives and to do things like engage in services, rehabilitation, substance abuse treatment, get help from our social workers. And the outcomes have been substantially different because the data all shows that when somebody is out of custody pending their trial, their outcomes can be markedly better for them.
Patrice, I wonder if we could pick up there a little bit. If you could talk both about the advocacy that your organization has done on this law, but also about the impact that you see that, or seen that it have, not just on people who are accused, but on families and frankly, on the whole community.
Yeah, thank you. Number one, we know that the criminal legal system, the pretrial system in particular, has an outsized impact on Black communities and Black families in the state of Illinois. So the fact that the PFA passed is now existing is now providing more stabilization to Black communities. The original bail funds were created in communities, primarily Black communities, where it was Black women who were raising money and crowdsourcing, hosting fundraisers to get their loved ones, raise the money to get their loved ones out of jail pre-trial. Those were the original bond funds. And now that is money that is able to stay in people's pockets. These are also mostly low-income families that are now able to use these resources to continue to support their families. So having more money in people's pockets to survive and to live is just been a real positive result of the passage and implementation of the Pretrial Fairness Act. I would also say that jails are extremely destabilizing to individuals. These are often people who are already going through various struggles, trials, et cetera, and jails do nothing but further exacerbate that, cause pressure in the homes. People often lose, financial contributors to their families. And so having people be able to get back into community, get back to their homes, provide support, whether it's financial or emotional, is very important.
The other part of the question is the impact sort of on, I think you sort of touched on this, on families and on community writ large. And again, I think if you see how you see your organization's advocacy for this law in that context of those changes.
Right. I also think the advocacy in our organization's role we were able to have deeper conversations with community about what is actually safety, what actually makes people feel safe. And overwhelming the response is not jails. It's not more policing. It's not more arrest, right? It is the supports. People in Black communities want access to resources and to supports. They want jobs in their community. They want safe and affordable housing in their community. They want quality schools and quality childcare providers. It is rare that if you ask Black communities and individuals in Black communities what makes them feel safe, it is rare that they would say arresting more people. And so I think that, being able to have deeper conversations, but also now with the implementation, we know that, the sky didn't fall, right, when this law went into effect. And so Black communities who have historically and continue to be over-policed are not in a worse position because of this law.
Thanks. And we're going to come back to the sky didn't fall question. So for Liz and for Michelle, I wonder if both of you could, for a moment, sort of talk about you've talked a little bit about the procedural changes, the process. I wonder if we could drill down a little on that in terms of how this has changed, like your relationships with your clients. I presume having an hour hearing with a client changes the relationship with that client as opposed to a 5-minute or 4-minute hearing, for example, how it changes that relationship in that way, and how it changes, I think, sort of the arc of the cases and the outcomes in this way, and whether or not you're able to sort of see or forecast anything there in the limited amount of time we've seen under implementation.
Well, I do think it's really easy to see defendants as a number, especially in a public defender's office. The cases are coming through so quickly that it is hard to focus on any one person and remember anything about those individuals. These new bond hearings force us to stop, take a step back, and we're learning a lot more about our defendants at the very beginning of the case. We're learning a lot more about their families. We're learning a lot more about their jobs, their criminal history, the charges themselves, and whether or not they're sufficient. So being able to have that at the very beginning helps us to remember we're not just dealing with defendant number 49, defendant number 50. We're dealing with actual people who need our help. And so having that at the front end does start the ball rolling properly with our clients.
And I would add to that, I completely agree that, the investment on the front end it really strengthens the attorney-client relationship. But I will add that it has been incredibly difficult to find the time given our current staffing levels, because the amount of work that goes into preparing for a PFA detention hearing is about 5 times as much as went into preparing for a bond hearing. And we have the same number of staff and the same number of people that are authorized to be hired by our counties, unless we've been able to get them to give us, more staff and more money, which I've not heard of an office that has been able to benefit from that. So the time investment on the front end has really put a lot of pressure on us in terms of staffing levels. And it is a struggle. It's a struggle to find the time. I've got a lot of people working overtime to get these hearings prepared appropriately. And we have a rotating schedule because of the limited number of people that we have in the office. So it has been, I would say, a challenge, pretty difficult for us to accommodate what we need to do to zealously advocate under the new law. And that has been an issue. So that's also something that we probably need to address in the future.
Yeah. Patrice, I think the mention of resources sort of reminds me, we heard this morning about, that each year more than $100 million was spent in paying money bonds to secure someone's pretrial release in Illinois, and that money was often paid not by the individual, but by a family member, a neighbor, a friend, a coworker, et cetera. And I wonder if you had sort of hinted at this before, but I wonder if you could talk a little bit about what the financial impact, both of that previous system, but also of ending money bond is on families and the community at large.
Okay. Well, it allows families to do other things with the money, right? It allows people to continue to, pay rent or pay a mortgage, pay their bills, do activities, et cetera, with the family. I think what this has shown us is just how much money low-income people were spending to support essentially these harmful and carceral systems, right? And so I think that times are challenging for everyone, in particular right now with families that are low income. So having that money, keeping that money in the family, is better for everyone. One thing I did want to offer in this conversation about workload is that I wonder if it would be helpful if we reframe how we think about the additional workload and maybe think about this as this is just actually what should have always existed. If you are going to detain someone, if you are going to incarcerate someone, there actually should be a really high standard for that. And so absolutely offices, public defenders, I'm sure state's attorneys, court administrators, et cetera, need additional support and resources, absolutely, but that should have always just been. And so I think it would be really helpful if we think about what should it actually look like to detain people, and that should just be the baseline.
Thanks. Michelle and Liz, I'm going to come back to you. We heard a lot about electronic monitoring or other kinds of conditions of release in the data this morning. And I wonder, since you two have sort of eyes on the inside of the system, if you could talk about sort of what you're seeing around those things and what impact the PFA is having on conditions of release, electronic monitoring, other things in that area that the two of you are seeing.
Well, in Macon County, electronic monitoring became much more widely available once we started with the Pretrial Fairness Act. We rarely use it. And one of the reasons we rarely use it is from a practical perspective on the state side of things, individuals will get custody credit for that. And the state does not want to provide that custody credit for the electronic monitoring. And not only that, it's such an expense. And individuals who are placed on the electronic monitoring often can't afford to pay the expenses. And so because that's not something they're going to be forced to do, the company is eating the cost, the state is eating the cost, and our state's attorney's office doesn't explore it very often. When we do use it, it's very effective to use it on cases where they're otherwise going to be detained or have been detained, and perhaps forensic testing is delayed. That's happening a lot. It can take 6 months or more to get certain forensic testing done. And if it's delaying the outcome of the case, that seems to be a good way to allow somebody out of pretrial detention with some safeguards in place. Other than electronic monitoring, we make good use of substance abuse assessments and treatment, mental health assessments and treatment, where they're ordered upon release to go to our local facilities, get those assessments done, provide it to our local probation office because we are not yet part of the statewide pretrial services system, and they are monitored by our local services. And they bring that proof that they've started the process before they even come to their preliminary hearing date, their first real court date. And that helps us to get people directed toward treatment if that's what they really need. And it helps us to negotiate the cases as well. So I think those kinds of services are used the most by us.
So just to underscore, so you're not part of the statewide system, at least as of yet, so that cost issue becomes high for people to pay for that.
That's correct. We are in the process of moving to the statewide system, but we'd already had an infrastructure in place that we were using. But then as the statewide system has evolved and it's handling more things, it just makes sense for us to move to that system as well.
Yeah. Liz?
Yeah, so we are using electronic monitoring much more substantially than we were before the PFA went into effect. And part of that is because we're able to not have our clients have to pay for it. So I don't know a single client who would not agree to be on an electronic home monitor at home rather than be stuck in the county jail. The problem was beforehand, it was the client's responsibility to have to pay the daily fee for that monitoring. And our clients can't afford the bond, much less the electronic monitoring fee. And so now that OSPS, which we do have in Champaign County, OSPS has absorbed that cost, we're able to present that to the court as an alternative to pretrial detention. Because as the statute requires, there has to be, if there is any combination of conditions that is going to ensure the safety of the community and the defendant's presence in the courtroom for their court dates, then that is what the judge should do. And so now we have this alternative to propose where if the court does have a concern, like for example, in a domestic case where there's a no contact order and they're worried about whether or not the person's going to go to the alleged victim's house, now we can say, just put them on a monitor and that will ensure the safety of the person and they don't have to stay in the jail. So it has given us this kind of wealth of other options to present to the court so that our clients are not detained. And we have made significant use of it here in Champaign County.
Patrice, you I think touched on this a little bit in one of your previous answers, but when you think about this, we're, again, a year into implementation of this new law. You talk to communities across the state of Illinois. What do you think we've learned? And what do you think that policymakers should be thinking about when they hear, calls to amend or change or alter the law in any way? And I wonder if you have a prescription of anything that you'd like to see changed.
Sure. I think it's still early, right? We are still, I should say we, Dave and others are still gathering research and looking at the data to see.
We're all Dave today, and I think that's what we've concluded.
We're still learning, so it's too early to do much of anything. I think that what I am most interested in as we have this conversation about electronic monitoring and pretrial services and et cetera, one of the things that I think that has to always be remembered and considered when it comes to Black communities is the outsized role that carceral systems play on Black communities. So when we think about pretrial services, electronic monitoring, I would like to really better understand what pretrial services is looking like. What does that mean exactly? If someone is on pretrial services, how many people is it that are just, have to do a phone call check-in? How many people have to do more constant and consistent check-ins, how many have to go to an office, et cetera, to really understand how is this impacting individuals and how is it impacting communities. What we know about Black communities is that we know that they're heavily policed. We know that people who live in Black communities are people who are on parole or maybe federal parole. In Illinois, mandatory supervised release. There's already a lot of what I would say is surveillance of Black communities. And so I'd like to really better understand how pretrial services is impacting that. Because also, when we talk about services, et cetera, in smaller communities, there aren't as many resources to go to, there are not as many service providers to go to. We also don't want to make process the punishment, right? You can assign so many services to someone pre-adjudication of the case that the process really did become the punishment. And so I think I would really like to understand how pretrial services is impacting individuals to also better understand how it is impacting communities.
Michelle or Liz, is there anything you guys want to add to that? And I wonder about your sense about services, or if you want to add any more about the need for additional resources and on the public defense side.
I am one of those lucky counties that has a very supportive county board, and they're trying to give us the resources we need. And of course, the state of Illinois has also provided public defenders' offices with some additional funding. And that's fantastic. We appreciate all the funding. But unfortunately, for me at least, all the funding in the world isn't getting me the warm bodies that I need to fill my office. We're having fewer applicants. And so I think that's been an ongoing struggle we've had for several years in Macon County, is finding enough attorneys who want to come do public defender work. We've been lucky to be able to use contracts with our local private bar to help us with a lot of the Pretrial Fairness Act things that are going on. But resources are certainly lacking in our office. There's also been a movement that I think would be very interesting. Some offices have social workers. And at first, I didn't quite understand how we would really work with that, how there would be a connection there. But the more I've been immersed in the Pretrial Fairness Act things, it would be wonderful to have a social worker on staff, someone who is able to handhold our clients, make sure they're getting housing if they need it, helping them to fill out the job applications, making sure they are able to connect with the services, as opposed to me in court handing them a piece of paper and saying, just go to this place, someone who helps get them set up. So those would be amazing resources to have. And I do feel for the communities that don't have a lot of things available, like substance abuse or mental health treatment. Decatur does have some of that, and we're able to send clients for assessments. We need to see more of that in the smaller communities.
Yeah, I would agree with that. And I mean, we do have providers in this community. We've got mental health providers, we have substance abuse providers, and they're never going to be enough because there is just a general underinvestment in those kinds of services, I think, across the entire state. It's more pronounced in the more rural communities, but we suffer from that here as well. I think that in terms of just resources in general, I mean, our client base and the people that we represent are indigent by definition. So they're not going to be able to afford those services on their own. And it is difficult to engage when there are waiting lists that are 3 to 4 months long before you can get in to see a provider. Thankfully, and our Office of Statewide Pretrial Services has done a very good job here in Champaign County. They're not assigned to every single case, but they are assigned to cases where people are struggling with mental health issues or substance abuse problems, and they actually do the connecting to those services on our clients' behalf. And they take them, they sign them up, they give us reports about how they're doing. They do not give those reports to the state's attorney's office, so we are connected with them in that way. And I think that has been helpful in terms of the dollar investment in getting somebody to help coordinate those services. But ultimately, I mean, the public defense system in general is tragically underfunded. That's true across the country, and it certainly is true in the state of Illinois. We haven't had an update to our national workload standards since the 70s until very recently. And very recently, they basically found that when it comes to the national workload study that we should be adhering to, we're all understaffed. There isn't a single county public defender office in the state of Illinois that has an appropriate level of staff. And that doesn't include just attorneys. It's social workers, it's secretarial staff, it's investigations, it's all of it. And so there needs to be a wholehearted investment in this system. Otherwise, we're just telling the people that we represent that they're not important enough to matter.
Because I think overhanging all of this discussion today is we all saw the commercials, right? We all heard the nonsense for months about what this law was going to bring. And guess what? It turns out there wasn't a purge. In the same way people are not eating cats and dogs in Springfield, Ohio, as we've talked about today, there was not a purge. It was nonsense. And so I guess I'm wondering, from each of your perspectives, sort of how you look back on that now, number one. And number two, what you think of what was it that some of those folks from within the system were so wedded to in the old system that caused them to jump to that kind of hyperbole and to, to claim that to the point that now they have to sort of say, well, yeah, it's kind of working. And I mean, it just seems to me that maybe if you don't get your head out over your skis in the first instance, you don't have to backpedal, like the road runner. At the end of the day, if I can mix my metaphors, in order to get there. And I would have asked Eric Rinehart that question in the same way, I promise you. But I open that question up to any of you for your thoughts on that.
Misinformation thrives. I mean, that's the society we live in. If people want to take a stance on something and they are just determined to take a certain position, they'll find any reason they can to support it, whether it's based on any fact or not. At the end of the day, we did not see a purge. Frankly, when I look at our jail population, which is down about a third from where it was, that third, for the most part, are those really low-level retail thefts, drug charges, things of that nature. And the people who are in our jail, for the most part, are in there for gun offenses, armed violence, murder, armed habitual criminal, a lot of very serious things, including domestic battery. So it was always unreasonable to think we were going to have the purge. And frankly, I think that the judges are just being a little bit more deliberate now because of the statutory framework, being more deliberate in who they're detaining.
I think fear is always a problem and change always scares people. So I think that was just a lot of projecting because anything, there are certain parts of our system where anything that benefits a defendant is going to upset some people. And I think that there was a lot of really unwarranted fear about what this was going to do to the system. And in fact, it has made it function better. So I wish that people maybe would not have engaged in such hyperbole when they were talking about this in the press prior to it occurring, but I'm glad to see that the fruits of our labor have borne out.
I think I would only add, I don't know if this is accurate, but I always wonder about the economics of everything. And I could imagine in counties where people rely on carceral jobs for employment and there may not be as many alternatives, I could imagine that there's real fear around how is this going to impact people's livelihoods and jobs. And fear is a powerful tool as well as financial security. So I could imagine that also was a factor.
I can't resist just asking, I suppose, as a follow-up, and maybe I'll start with you, Patrice, because you had sort of referred to this before about what communities want. And I think that one of the realities is that people don't really accept the binary choice we often make between, tough on crime or soft on crime and all of that kind of thing. And I wonder if you think that there's some of that people just thought that was the way they have to play that debate as the result of these kind of set things we have in mind, when that's not really the way voters respond around these kind of public safety issues.
Right. I think we don't give people enough credit for nuance. And I think nuance is real, but nuance is hard and sound bites. Right. I think people recognize and understand that there are real needs in communities. There are real needs that individuals face, and people every day struggle to have those needs met. And they recognize that there are limitations to a lock 'em up mentality.
Eric Rinehart, it's good to be with you today.
Thank you. Thank you so much for having this. Thank you so much for having me. I look forward to answering any questions, and I apologize for being late, so make the questions tougher.
Well, I will take you up on that invitation. I wonder if you could just talk for a minute about, I think in general, we heard a lot today about data and the way the new system is functioning. And I wonder if you could just take a moment to kind of talk about the how you prepared for the new law and how you see it operating as compared to the old system.
The phrase Safety Act is broader than bail reform. And one of the ways that I worked to prepare was to make sure that we trained our law enforcement officials in the streets, because so much misinformation started with what was happening in the streets, and I talked about slowing the process down. A police officer has to make second by second, minute by minute decisions. Here she is the street, and that's making. Well, it's called an A3 release. That's a release on a felony, a citation, and then release. And then I want you to imagine the third level, which is in the courtroom. If judges and lawyers are learning a new statute and have to look in their binder, what's the problem? What's the big deal? Booking rooms, we know that they can be dangerous, but they are a much safer place because there aren't weapons. So if a police officer or a sergeant has to look at a flow chart, okay. So that's okay too. The first thing I did was spend hours personally training law enforcement about how this act was a good thing and how everybody was going to stay safe. Once we did that, I think we saw amazing buy-in from law enforcement as to that process and recognizing that we can keep people safe on the streets and that the cases that should be detained will be detained, but that in fact, many cases will not have pre-trial detention, and that many stakeholders are okay with that at the end of the day, and that's a much more certain system for victims, and it's a much better system for decreasing the trauma of front-end incarceration.
I want to go to questions from the audience in just a second, but I wonder, Mr. Rinehart, if I could ask just one more question that some of our panelists had discussed here, but just to shorten my longer question, we heard a lot of fear and hyperbole going into this. With some people in the system, some of your fellow state's attorneys from around the state have had to sort of walk back. And I wonder if you have any insight in sort of what that process says, what it was, and why it was that people were so wedded to the past system that was dependent upon money.
I think that there was so much misinformation about who could even be arrested that I actually think that some of the lies and misinformation had run halfway around the world before we had gotten our shoes on, and didn't even really explain to people that offenses can, and I'm going to use the word handcuffing, even though that's informal, that almost all offenses can lead to handcuffing and de-escalation in the sense that, the retail theft person is taken out of the store. But many groups were talking about how they couldn't even arrest people anymore. And I have to say that was incredibly damaging at the beginning of the debate. And I think that all stakeholders should have done everything they could to make sure that misinformation didn't get out there. There was then more misinformation about everybody getting out at midnight. Some people were treating it like Y2K. I've made that analogy before, that literally the cell doors would slide open and that no human beings in the world could stop that. And that misinformation was so damaging. And so the fact that we are seeing that crime is down, the CBS report today talks about crime being down. People have probably also heard me say we need a lot more up-to-date statewide crime statistics. But it's great to hear that CBS is making that report. I know that crime is down in Lake County. But we need a lot more crime data. And I know Dr. Olson, David Olson, is a big advocate for that too. But if we can have crime data and we can see that a reform like this, which is good for people and is fair, and then we can say on the other side of it, look, crime didn't go up, then I think we've done a lot of good.
First, for the public defenders, obviously, you mentioned that there's a lot more work going into this. But do you think that's also made it easier, that work on the front end, to defend your clients, because you have to take the time to get to know the case, because obviously you have to be ready for that initial hearing?
To an extent, I do think it makes things easier. I've had the opportunity to read the police reports and go through the sworn statement. So I'm already making notes at the very beginning about problems that exist in the case, whether it's a problem for the state or it's a problem for us. Those notes are already there and they help kickstart us as we go forward. Does it really decrease the man hours we have to put into the case? probably not in the end, but we do have a better grasp of the cases at the beginning than we do rather than catching up later on.
More what I was getting at is, does it make just defending, make it better, easier to provide that vigorous defense just because you have to get into it earlier?
It does, because we're already presenting that defense on day one. Mm-hmm. And so we're already starting with looking at, hey, there's a self-defense claim here, Judge. We need you to look at this. And it helps kickstart us.
Yeah. And then my next thing is probably for the state's attorney, but for anybody, is there anything a year in, and maybe it's too soon, that you change, that you think lawmakers should take another look at, whether it's adding or subtracting detainable offenses or giving more discretion to judges? A year in, what would you change?
Well, we're not even a year in, and so we certainly are making sure that we're getting this right. I think that the victim support is incredibly important, and I think that from our perspective, having that early victim contact, which our office has always done a great job with, but it's when there's a court date coming up tomorrow, it focuses the mind, right? And so our victim specialists are reaching out to victims earlier. That's another case that the way that the system front loads the work. I think that some more explicit language might be good in the probation setting, or the violation of probation. The violation of probation language in terms of what happens for violating probation through a technical violation, not a new offense. Obviously, a new offense could be detainable, and so that person would be detained. But I think there needs to be some additional procedural language about how to deal with violations of probation.
Anybody else want to offer anything in terms of things they change?
I guess one thing I would say that most people probably don't know about, the difficulties with clients who are on pretrial release is that it's hard to keep them on pretrial release sometimes. I know we've talked about the numbers of people coming to court and the people are regularly appearing. We're not having that experience in Macon County. We're having a lot of people not come to court. That triggers the state to file petitions for sanctions. That's an additional court hearing we're going to have to do once they're picked up on that warrant. And then we've also got individuals who are on pretrial release who then pick up a new offense. And then there's a petition to revoke the pretrial release they already have. And that oftentimes gets us sprinting between different courtrooms if cases have already moved to different spots. So that can be a bit of a problem for us. So I would like to see something change that, I don't know how we streamline that process, or something that doesn't have us running around like the house is on fire all the time.
That makes me wonder if if that is where the expansion of the pretrial services could really be helpful, where you have an agency that is tasked with supporting people once they are released to get back and forth to court while also maintaining the responsibilities of everyday life.
Liz, I wonder if you have any extra thoughts, and I know you're going to have to leave in a few minutes, so I want to also offer you a chance for final thoughts in this discussion before you have to go. And I should say she has to leave for a hearing, not because she just doesn't want to be on Zoom anymore.
I appreciate that.
Yeah.
I mean, I think that there are probably a lot of details and a lot of tweaks that we could make to the legislation in the future that would smooth the process and address, some of the concerns that people have expressed from both the state side and the defense side and the community side for that matter. But what I will say is that overall, this law has been exceptionally good for our clients. And as much as the extra work has cost us and as difficult as it is, it was the right thing to do, because nobody's income or amount of money that they can post should be the deciding factor for why they are in jail or not. And so my final thought is that I appreciate everybody who participated in the implementation of this. There are some changes that we can make, and we need more resources to really do our jobs adequately. But the structure of the law is good, and the benefits to our client base is indisputable.
This is a question for the public defenders too. I was wondering, because I know you guys mentioned that something that would help would be more applications to staff your offices. I was wondering just what kind of support do you want to see from our state, from policymakers, and that could maybe help with recruiting more lawyers to join?
The one thing I thought about would be something along the line of student loan forgiveness. Law school is incredibly expensive. It already is beneficial that we have public student loan forgiveness for people who do public defense work. So after 10 years, their loans can be forgiven. That's really great. If we could do more things like that, ways of offering state bonuses, incentives to get attorneys to move to maybe the less desirable counties, because it is really hard in rural Illinois to attract a public defender, or attract any attorneys whatsoever for that matter. And so if there were maybe financial incentives or helping with moving that can be provided by the state to help us get those individuals in the door, they sign contracts to stay for a certain amount of time, perhaps that's a way we make sure that the talent gets spread out throughout the state and gives us those resources.
One of the fears as this law was being debated was that there would be an increase in people getting out who otherwise would have been detained and then committing additional crimes. In particular, people arrested for domestic battery, stalking, those kinds of relationship-based crimes, getting out and having access to their victims again. I'm wondering, has there been an increase in that? And I ask both the defenders, and I see that the state's attorney is back on there, Mr. Rinehart.
Yeah, I'm happy to answer that. Thanks for waiting for me to get on camera, everyone, towards the end here. That has not been happening. So you have to imagine whatever the release rate was, and all the data is still coming in, particularly from Lake County. I wish we had a data culture starting 10 years ago so that we could answer that question better. That you got to look at what the release rate was before in terms of posting cash, and you have to look at what the release rate is now on domestic violence cases with non-cash. My belief is that if judges are doing the safety assessment correctly, the state is filing the petitions to detain, and then the judges are doing the assessments correctly, that you would have the most dangerous offenders being held without any possibility of getting to their survivors. And what a moment of certainty for a survivor of a crime, right? When the prosecutor or the victim counselor is able to say, well, you know, your attacker is now detained, you know, until next order of court, indefinitely, whatever it may practically be, as opposed to somebody posting cash at 2 a.m. I think one of the difficult parts of this debate has been the lack of understanding. And it's okay, people aren't lawyers, and most people don't have loved ones in the justice system, but the lack of understanding from people who don't have loved ones in the justice system or aren't impacted directly by crime, the lack of understanding that people are posting cash at 2 a.m. at night, and that's not a great safety approach to start with. And so the criticism of this bail reform didn't seem to really price in the number of people who were posting cash to begin with. So the critics of the Safety Act were saying, my God, we're letting people out, but we're sort of silent or ambivalent on the amount of people posting cash and getting out and then hurting somebody. I mean, the Will County case alone, where the guy posted $10,000 and then shot 7 people. I assume there was an uproar from some of the critics of the current critics of the Safety Act that they were using a cash system. I assume that, and that's why I've never understood, is that none of that was seemed to price into the criticism. I didn't understand that.
And I don't find we're seeing a lot of recidivism for domestic batteries. For the most part, what we're seeing is a person who gets released on a domestic battery usually isn't getting picked up on a new domestic battery. What seems to be most common is that by agreement, even though it's against court order, the couple gets back together. And we have a violation of pretrial release for them getting back together with that person. No new acts of violence. But the reoffending we see doesn't typically come on crimes of violence. The reoffenders we see are typically the same people we would have seen reoffending before, which would be on theft cases, drug use cases, because unfortunately, addicts, they aren't getting the treatment they need, and that's how they are supporting their habit, is through theft. So I feel like in terms of reoffending, most of our reoffenses are based on minor things like theft or drug use.
I wonder if I could just jump in quick with a follow-up then. for both of you, as you've talked about that, has the Pretrial Fairness Act implementation changed at all the way in which victims or survivors of violence have been integrated into this process?
From our perspective, the victims and survivors are being contacted much earlier and brought into the process much earlier. Typically, under the old cash system, because you didn't have two court dates, you'd have a single court date and then a cash value would be set. And maybe the victim made it to court that next morning. Maybe they didn't. They're closer in time even to the trauma of the event. They're still in the trauma, certainly. It's this second court date where there's a detention hearing if a petition was filed, where we have a lot of opportunity to connect them with services because there's instantly this second court date and to make sure that they get what they need. So I think that's a great question. And I think integrating survivor support into that, 48 hours, and certainly the defense can agree to extend it. But within that 48 in a felony, that's a really, really great part of this criminal procedure. By the way, that type of change is a pure criminal procedure change, right? Like that isn't as much about cash versus non-cash, detention versus non-detention. Some of the parts of the Safety Act were just a change in criminal procedure. That's probably a good thing, but people knew very little about criminal procedure until the Safety Act. And so again, some of the criticisms that we saw in the Safety Act were already true prior to the Safety Act. For example, this terrible criticism about, and I'm sorry, I heard a very prominent member of the legislature on the floor of the legislature talk about subpoenaing victims to court cases during bond hearings. Folks, you can subpoena victims to cases prior to the Safety Act. You could always subpoena victims to court cases. That criticism was in such bad faith. That was always true. The Safety Act actually gives you a way to have a judge decide whether the subpoena is valid. But that type of procedure was always allowed. The lack of information about criminal procedure was one of the big barriers. The lack of pre-Safety Act procedures was one of the big barriers to making this, to implementing this. And I think things are going well now.
I think I'm seeing more victims in the courtrooms at that first detention hearing, in particular when the clients are in custody. And it's beneficial to both sides to have that alleged victim in the courtroom just to figure out what it is that person wants. It helps us to assess the case as well, because sometimes a person will make a claim against the defendant and then turn around and say, I'm sorry, I exaggerated, I was drunk, I made it up. And that's information that's very important for us to have at the beginning as well. As well as, so it's good to know.
I was the one who interjected the subpoena. When we're seeing more victims in the courtroom, that's purely voluntary. That's because they've been reached out to by the prosecutor's office, by victim support. And that's the subpoena point is a separate procedural issue. But I do want to say the victims that are coming into the courtrooms are not there because they've been in Lake County. I don't know that a single subpoena, a year later, I don't know that a single subpoena has issued, which, by the way, was exactly what the world was prior to the Safety Act. Nobody was issuing subpoenas before or after the Safety Act.
But I think it does help that the victim's given that notice on the scene, which may not have been happening as much as it should have before. So it has been really nice to have them in the courtroom. I think it just gives us a better picture going forward for both sides.
Michelle, you mentioned earlier that Macon County is not currently utilizing the Office of Pretrial Services, but will soon be transitioning to use that. Maybe you can kind of expand upon, why that is, what the benefits to being part of the statewide network are, and then maybe the state's attorney can chime in too, because I know Lake County runs their own system and why they're going that way.
Macon County was very lucky that we have a very good probation office that already has had pretrial services in place for ever. And we've had dedicated individuals who what they do first thing in the morning is they interview the people in the jail and get our pretrial bond reports to us. Sometimes by 8 a.m., we have everything we need for the day. And they do a really good job of making sure that they're catching up with people, giving them all the information they need. That's why we tried to stick with that system to begin with. But I think that there's now much more pressure on the people who are not part of the statewide movement to go into the statewide program. And that's why we're doing that. We wanted to make sure we weren't going to lose the personnel we had, because we do have some very good probation officers offering the services. So I think they wanted to make sure those people were protected. But now as this pretrial services program has expanded throughout the state and it's offering more and more as time goes on, we're seeing the benefits of moving to that system. I mean, the idea that my clients might get a text message telling them when their court date is amazing to me because we can't provide that service from our office. But to know that maybe the statewide service can, or they can get them connected with services for us, I mean, that's just increasing what we can already do. So it makes sense to go to that statewide system.
This is kind of a two-parter question. We've seen, at least based on kind of statewide data, that oftentimes, not the majority, but a lot of times when it is detention eligible, people are not petitioning for those cases. I was just curious in terms of Macon County, where right now electronic monitoring is not as accessible. Mm-hmm. Is there more petitions being filed because people are like maybe trying to counteract that, and how does becoming part of the statewide Office of Pretrial Services, does it have any impact on whether or not more detention eligible requests might be filed?
The question about electronic monitoring is interesting. I don't know if that's going to change our approach or not, because again, I know our state's attorney wasn't fond of it because they don't want to give the incarceration credit for it. And in their minds, they would rather have the detention than the electronic monitoring. And we've also experienced difficulties like timing, getting the monitor put on. Sometimes they need 24 hours lead time, so that leaves people sitting in custody longer than it should. And so I don't know if that'll change or not. I'll be interested to see. In terms of detention being sought, I would say our bond court numbers haven't really changed so much over the last 2 years. So before the act went into effect and now. The state does seek detention on a good number, but largely if they're asking for detention, it is on a violent offense. It's got to be, we have a lot of armed violence, possession of weapon by a felon, attempt murder, vehicular invasion. Those types of charges are where they're seeking detention. But we're also finding that the state's looking through the charges to see, is this really one where detention is necessary? And knowing that our judge, who is handling the majority of these, is incredibly thorough. She's super careful as she goes through everything. She is going through every factor. She's looking at criminal history. She's looking at the nature of the offense. And so I think part of the dynamic in seeking detention is looking at, are we actually going to succeed in getting detention? Or should we ask for conditions and then ask for whatever conditions we want, which often does include no contact orders and getting treatment. Less often home detention or electronic monitoring.
What goes into determining whether you want to ask for pretrial detention or electronic monitoring or not filing any petition, even if it is a detainable offense?
We're filing in detention, we think, in the 70% to 75% range if it is a detainable offense. I always caution a little bit about calculations, because what's a detainable offense? It gets really complicated on the class 3 or higher if there's an argument about willful flight. I've had some arguments about the phrase detainable with some members of the press about that. But many things are quote unquote detainable if there's also an argument regarding flight. So the percentages are a little bit complicated to figure out. But what goes into it is exactly what would go into a decision regarding quote unquote high bond. I mean, for those of us practicing, we all know that a state's attorney's office or an assistant prosecutor would say, "Judge, we're asking for a high bond," or a supervisor would tell a prosecutor, "Go ask for a high bond." Well, whatever those factors are, we're talking about in detention. We're talking about how serious the crime is, what the harm was. And what the what the ability is for the defendant to have a place to live or what their stability is in terms of after they have been arrested, in terms of whether they would be a threat to other people because of their situation. It's really a threat to the community, which is exactly what judges were thinking about when it came to quote unquote setting a high bond. I don't think it's that complicated, except for the fact that people didn't really want to unpack what they were thinking about when they set a high bond. And by people, I mean judges. So from our office's perspective, we have a line assistant looking at it, as well as supervisors to make sure that we're not under or over detaining. And so we put a lot of prosecutor resources at the front end. And that's a really good, that has other good effects, by the way, that some other folks have talked about in terms of working on the case. And it is a really big decision. And one of the reasons that I've been for this reform is because it also acknowledges that cases take a long time. And so if we're going to have cases take a long time in an overcrowded system, it's a big moral decision whether to hold somebody, and we shouldn't leave it to the uncertainty of posting cash on either end of the spectrum. So if we acknowledge that the criminal justice system can take too long at times, then we better have a really fulsome process at the beginning when it comes to something as important as detention.
I kind of wanted to touch on the mentality of some of the opponents going into the implementation of this system. And this is for anybody who might be interested in answering, do any of you think that maybe the opposition to this and also just kind of the general outlook towards people who have been arrested is kind of based in like kind of more societal trends where like things like the police don't arrest people if they're not guilty, or if people are guilty, they deserve whatever punishment they get, regardless of whether it fits the crime, that sort of thing?
I absolutely think that is true. I think that we as a society, as a culture, have leaned very heavily into this punishment idea. I think we have shows like Law and Order that run 24/7 nonstop. All of that plays into the psyche of the American psyche. We are a punishment-driven society and culture, and so I think that even if we can look at the data, if we can read the research and say that like it doesn't work, right? I think the length of sentences, we know that there's a certain point that sending someone to prison for 50 years, like there starts to become a point where that's just like actually not useful. But I think that, in addition to what we are fed through the media, it has people terrified to go outside. And so, couple that with a conversation about releasing people, I just think it's sort of a recipe for disaster where people don't like to hear it and don't want to have actually a meaningful conversation about it.
It also does. I love that point. It has a lot to do with that release moment. I always think about Paul Manafort. I don't even know how long they investigated Paul Manafort. And I always think about this moment where he's walking into the federal court and then I think they had worked out a deal right away. And then I don't know if he was taken off the floor immediately or if eventually he went off the floor. But like while they investigated Paul Manafort, he was investigated for months and he was out free. And then one day he wasn't. Whatever you think about Paul Manafort and whatever you think about white collar crime, people don't really think he wasn't punished. I think he was pardoned, by the way. That's not my point. My point is people don't really think he wasn't punished just because he was walking around during the investigation. I think people have a psychological problem with that release moment, not so much that there are times delayed punishment. It has to do with that release moment. We'll have non-detainable offenses. And in Lake County, the judges sort of read the Riot Act about how it's actually critical of the legislature, to be honest. It criticizes the legislature for not making this a detainable offense. Well, Lake County judges weren't sitting at the jail counters at 2 a.m. reading the Riot Act to anybody about how cash lets people out. I've never understood that. But the Riot Act is read every time somebody isn't held. But nobody was worried about the amount of release for cash, and so I think that the critics of the act really started out on the wrong foot, and at times were proceeding in bad faith because they never dealt with the other part of what was happening in the cash system.
And I think one thing about American culture is we really are. You are side A or you are side B. You are good. You are bad. You are a Democrat, you are a Republican. You love Taylor Swift, you hate Taylor Swift. Everybody has a strong opinion on one thing or another. And I think that spills right into the criminal justice system. You are charged with an offense, you are bad. You are not charged with the offense, you fall under the good. And I think it's just something that plays right into the system, and we just assume that when people are arrested, they fall under bad. And we don't look at it any closer until, frankly, it affects us personally. You have that close friend or family member who's involved, and then you start to see, wait a minute, this person isn't bad anymore. But when we're just looking at it as a large group as a whole, we just can't get beyond that dichotomy.
So I'm going to take that Matt and Charlene have given me a microphone and this question has been asked, and so I can't resist. I would disagree slightly, Michelle, only in this. I think that is the narrative that's the way people feel. That's not how people feel if you go out and ask them. Mm-hmm. They understand the nuance. But we've been asked to see things in only this black or white, and we can debate Taylor Swift later. I'll give you one of my friendship bracelets. But, we really have to move on from this idea that people who are very concerned about public safety do not want a system where we over-police black communities, as Patrice talked about before, where people who are concerned and want their kids to be able to walk to and from school don't want our county jails filled with people on low-level drug offenses. That is not the way voters and people actually feel, but is the way we've created a narrative where elected officials and oftentimes, people commenting in public respond to it. And I think in this debate, it just fueled this. And I just, getting down to the real politique of this, we had 2 years of multi-million dollars being spent against this bill. And it turns out it was all wrong. It was wrong. And nobody has ever been held account for that. And it boggles my mind that you could be so wrong about something and never, ever, ever have to answer the question about why you were. And I think, as we look for this 1 year anniversary, when we get to 2, when we get to 5, there's some people who have some answering to do around these issues. That's thus endeth the lesson. Did we have one more question? Matt, okay, I promise I won't answer this time, Matt.
This one's for the state's attorney. Having to do the work on the front end more, has it made prosecuting easier and prosecutorial decisions easier, whether it's choosing to even move forward quicker or just because you have to look at the evidence so, take a deeper look quicker?
Well, it certainly has the, it has the benefit. I can talk about it because I won't be specific about it, but there was a juvenile case where the wrong person had been arrested. And in juvenile, as you all know, there's no cash system one way or the other. It's always been a detention system, a safety-based detention system. And there was a lot of work at the beginning, and people quickly realized that they had arrested the wrong person. And so instead of somebody sitting in jail for 37 days or 37 years wrongfully, it was actually a false confession case. The person was in custody for 37 hours. Not great. I'm not saying that's a good thing. I'm just saying it was not 37 days or 37 years. So, but it's very serious. It was a shooting case. And so I think that front end work prevents wrongful prosecutions. Look, I don't think people who are striving for justice or safety, frankly, should complain about work. We are public servants. We are here to make our society better, to make our community safer, and to protect people and families. The fact that public servants would say this sounds like a lot of work was kind of surprising to me. And I love this idea of holding people accountable. To make their best argument, I think they were saying that this is a lot of work and mistakes might get made, maybe, but they weren't always saying that. Sometimes they were just saying this is going to be a lot of work. Well, how much money should we pay to get justice right? How much money should we pay to get safety right? How much money should we pay to get equity right? And so investing in the front end is supposed to relieve some back end pressure. And so I think that front end work is a good thing. And we moved lawyers around. We had to hire a couple new lawyers, but it didn't raise anyone's taxes. We just hired a couple lawyers, and we made the county board pay for it. And it's an argument that is, well, this is for safety. So I think I've never understood really that work argument. I think we should all work hard and work to the bone to make people safer.
Thank you. Michelle Sanders, Patrice James, Eric Rinehart, thank you all very much. and we will turn this back over. But thank you all for your thoughts today. Thanks.
Thank you.